Good afternoon. We're breaking into programming to take you to the Leon County Courthouse, where right now State Attorney Willie Meggs discussing the case of Florida State quarterback Jameis Winston. Here we go.
We wanted to be confident in the decision that we make and make sure we make the right decision. I've been in law enforcement nearly 50 years, and my prosecution experience has taught me that we need to handle each case equally and fairly, and it's a search for the truth. We did so in this case. Our city has two universities, major universities here, and we've dealt with athletes on prior occasions and made decisions at some time to prosecute them if the facts merited it. We've carefully examined all the evidence in this case and have concluded that no charges will be filed against anyone in this case. A public record of our investigation will be made available to anyone who wants it, and you'll be able to see the evidence that should lead you to us making the decision that we have made. I do want to commend Jason Newland here in the blue shirt. Jason was our investigator who has worked tirelessly for the last 13 working days to get us to this position we're in today, and I do want to commend him. This is Georgia Kappelman. She's our chief assistant. She's worked hand in hand in the case, and so I want to commend her for the job she's done and all of the law enforcement work that has been done in the case to arrive at this decision. So at this point, I'll be happy to attempt to answer any questions that you may have.
Mr. Meggs, can you say if this is this a vindication for Jameis Winston, or is this just not enough information to file the charges? I
will let you all determine that when you review the facts.
When you looked at the search warrant, it was clear that there was some accusation that there was a third person in the room. Can you explain how that third person was involved, and were there any other people questioned as possibly responsible for?
Start the first of your question again.
Okay, the search warrant indicated that there was a third person in the room.
There were several people in the room when this event occurred.
Okay, and did you question?
They've all been questioned, and that's detailed in the reports that you'll be able to look at.
And how did you arrive at your conclusion that Jameis Winston should not be charged? Was there not enough information, or was it conflicting stories? We have a duty as prosecutors to only file those charges if we have a reasonable likelihood of a conviction. After reviewing all of the evidence in the case, we did not feel that we could meet that burden, and therefore we do not file a charge if we do not feel like we have sufficient evidence to make the charge.
Mr. Meggs, people are bound to say that athletes receive preferable treatment here in Tallahassee. Can you respond to any of those allegations?
Well, I don't think they do, and we try to treat everyone the same, and I think we have a record of doing that over the last 29 years that I've been state attorney. We prosecute the cases that we have evidence on, and we'll continue to do that.
How would you describe the Tallahassee Police Department's handling of this case?
We've worked very closely with the police department. Obviously, it would have been somewhat better if we had all gotten involved a little earlier, but we were involved from beginning on November the 13th, and we've worked hand in glove with them since then, and they've been most cooperative, and we've accomplished all the things that we feel like we need to accomplish.
Is there any indication that they mishandled this case in any way early on?
That will be something that others will have to decide. I'm not trying to decide that.
You said on Monday that there were a couple of pieces outstanding. Obviously, they've come in and you've made that decision. Can you tell us what those pieces were?
Yes, I can. In the laboratory work that we did, and you'll see that in the reports when you see them, in the laboratory work that we did, there were DNA from males. One was identified as being Winston's DNA, and the other one was unknown. And obviously, if we were going to proceed to trial, having an unknown DNA in a sexual assault kit would be a problem. So we had to make every effort to determine the donor of that DNA, and did so.
Mr. Meggs, do you think that if you had gotten this case back in February when it was put on inactive status, that the outcome in terms of you getting charges would be any different?
I couldn't speculate about that. I don't know that you know, we might have had some additional facts earlier, or there might have been some better memories. I don't know. Time is important. It certainly would have been nice to have known all the things we know now back in December.
Did that second DNA, did that cinch your decision this week?
Well, it was one of those loose ends that we felt like we needed to tie up. We felt like all the time we knew who the donor was, but until we have it tested, and you know, that was one of the things that was a problem to us during the problem with y'all during this. Everybody won't know what we're doing every minute of every day, and you know, we're saying we're still doing some things, and the lab doesn't work on my schedule or yours. And so it did take some time to do that. And I do commend the FDLE lab. They took this because they saw what has been viewed as important to expedite it, and they did.
And nothing in toxicology suggested that this woman had been drugged in any way or was incapacitated?
Those are facts that you'll find in the report that you see, but we've double checked it, and you'll find that in the test. Her blood alcohol level at the time her blood was taken was 0.04, which is not very high, and we found no evidence of any drugs of any sort in her blood system.
Was it an easy call for you to make not to file charges once the investigation was done, or did you have to agonize over this in any way, or how would you put that?
I think y'all were agonizing more than I was, but our standard of proof is what we go by, and we tried to follow the rules of evidence and the rules we're required to go by.
What time was that alcohol test done? Attorney earlier today and Mr. Winston's attorney earlier today of what your decision would be?
No, I have not.
Not the ones who haven't communicated with the complainant's family or attorney?
Yes, I have.
Can you describe whether you think there was a struggle based on the rape kit results?
No.
Could you tell us what the results of the subpoenas were, at least the one subpoena for the cell phone records, and what they produced?
You will have all of that. It would be quite exhaustive for me to try to tell you, and honestly, I don't know all of it. I've looked at it. But the copies of all of that will be available to you.
And did you ever consider potentially charging the alleged victim with filing a false report?
We did not consider such thing.
And because there was more than one DNA evidence in the rape kit, were you able to, can you conclude that there was perhaps sex with more than one male?
That would be a logical conclusion.
And Mr. Meggs, you were never able to match that second DNA to anyone?
Yes, we were.
You were.
So for that reason...
But not associated with the complaint that we had.
So same day maybe that it happened?
I don't know what day it happened. It's just...
Okay, is it possible that there was a third person involved in a sexual assault? And are you going to pursue that?
We have no complaint about a third person being involved in a sexual assault, and so the answer is no.
What was the family's reaction when you told them there would be no charges?
I spoke only to the lawyer for the family and
Miss Carroll.
Miss Carroll, and I think she understood because we've been in communication with her all along during the course of the investigation.
Was there pressure to come to this conclusion before the vote for the Heisman Trophy?
When are they doing that?
I'm not sure.
December 9th.
In answer to that, whenever they're doing it, there was no pressure, and I have not been pressured, and nor have I consulted with the football schedule or who the starting quarterback might be or not be. We worked as fast as we could with the time constraints that we had to arrive at a decision, and I think we arrived at the right decision.
Well, where did the physical description 5'9" to 5'11" come from, and did that have anything to do with your decision?
Had absolutely nothing to do with anything.
Mr. Meggs, could you tell from your investigation if TPD, any investigators, treated this case differently in terms of the investigation because Winston was a football player?
I do not believe so. Sometimes, communication is an art, and sometimes people, and I think y'all do that quite often yourselves, hear what you want to hear, and so I'm not really sure. I was not present when that happened, but I don't think it had that much impact.
So with that being said, did your investigators...
From the beginning, did he say he was there and it was consensual?
When you see the reports, you'll see all the answers. He hadn't said anything.
You know the family of the accused, what they have said in terms of how TPD has handled this case. In the past few weeks, have your prosecutors found any evidence that TPD tried to kind of brush this aside?
I don't think brush it aside. I don't think that would be the response that I would give. I mean, obviously, it would be better if it would have been handled a little different, a little earlier. But hindsight's always 20/20.
Now, with that being said, did you guys come up with anything during your investigation that makes you want to investigate TPD?
No.
Is there any reason you can think of that it would be a good idea when someone has accused someone of sexual assault to not get DNA samples of the accused party? Is there any reason to wait a really long time? What would be the reason to do that?
None that I'm aware of.
There was about a 5-week period between the initial report and the identification of the potential suspect. Was there any indication that the alleged victim knew the suspect prior to coming forward?
I don't think so. But you know, I think we could have identified the suspect in the case a lot earlier had certain things been done.
What are those things?
Interviewing more witnesses.
So after the investigation, is this more along the lines of you guys not necessarily don't believe this alleged victim, but just don't think there's enough evidence to prosecute, or you simply think her story is inaccurate and false?
Well, you know, I will let those kind of judgments fall to y'all when you look at the information, should you choose to do that. You know, very little can be profited by disparaging the victim in this case, and I can tell you that we do not believe, after we examined all of the evidence and interviewed all the witnesses that we could find, did everything that we knew how to do, and there may be something else we may need to do, I don't know, but don't think so. We came to the decision that it was not a case that we could bring forward because we would not have the burden of proof, the probable cause, and the reasonable likelihood of a conviction.
Senator Lawson, can you explain why you're here today, sir?
Well, you know, over the years, over the last 20-so years, on a lot of convictions in this area, because I represent the area, I always have found it very helpful to consult with the state attorney. He's always been fair, and like he said, there's never been a time where Mr. Meggs has ever backed down in their deliberation when an athlete's involved. And so, you know, he's always been fair in that regard and not treated him any differently. And so I've always had the respect of what he goes through and the office goes through in order before they have a conviction. And like any politician, you know that one of the things you're going to do is try to look out for your constituents and try to see if there's anything you can do to help. So, you know, I'm pretty satisfied with the deliberation in this case, and I just came by to support the state attorney.
You didn't call me a politician, did you?
No, I didn't call you a politician.
Okay, all right.
Mr. Meggs, you just indicated there might be something else that you could do. Does that mean that...
No, I said y'all might think of something I can do. I think we've thought of everything we can think of to do.
So there's not any chance that new evidence or more witnesses might lead to...
Well, I would never say there's never a chance that something might come up, but, you know, right now I have no earthly idea what that would be.
Mr. Meggs, the young woman in this case evidently did not know either man. Is that your conclusion? Did not know either men that donated DNA, as you described it?
No, that would not be true.
She did not know Winston, however.
She did not know Winston.
But she didn't know the other man?
I certainly think so.
So there was no prior relationship between Winston and the complainant before?
None that we were able to find. None that we were able to find.
And the DNA of the others, would it be described as someone who's a boyfriend?
I'll let you make that determination.
So the scenario you're describing is that perhaps she was engaged in sexual intercourse with someone and then Mr. Winston walked in the room?
No. Our report will not reveal that.
Was the other individual an FSU player?
No.
Mr. Mays, did you talk to anybody from Florida State, Coach Fisher, or anybody else?
No, sir. No, sir, I have not.
Was there a relation? There was no relationship beforehand between the two. Afterwards, no relationship either, right?
Between our victim and
Mr. Winston.
none that I'm aware of.
What about with the other person?
Clearly, there was a relationship.
I guess, was there a sexual assault?
Well, that's kind of why we're here. The allegation was that there was a sexual assault. Our job was to figure out if we could prosecute the case, and so we endeavored to do that.
Isn't it fair to say that if there was a sexual assault, you would have prosecuted the case?
If we had evidence to prove the elements of the crime of sexual battery, we would have prosecuted the case.
So do you believe there may have been a sexual assault, but not the evidence to back it up?
I know there was a sexual event that occurred, and one party says it was not consensual, and apparently the other side says it was, and that's our job, is to figure out if we had a forceful act, and we did not feel that we had sufficient evidence to go forward to bring the case to trial to prove that it was not consensual.
Can you talk a little bit about the reasonable likelihood of conviction standard and what didn't make sense in terms of that?
Well, what a reasonable likelihood of a conviction standard basically means is a law enforcement officer can make an arrest if they have what we call probable cause. Probable cause is reason to believe a crime has been committed and the person that they want to arrest is the person who committed that crime. A reasonable likelihood of a conviction is basically souped up probable cause. You raise it up a little bit, a higher level. Because, and there is a logical reason for that, and I'm sure that it will make complete sense to you, because when we get into a trial situation, the jury has to be convinced beyond and to the exclusion of every reasonable doubt. And so that's why we use that standard, and we use that in every case that we prosecute. And I think that's probably all over the country.
What do you wish the TPD did differently? And why?
I haven't thought about that very much.
About three more, guys.
Mr. Mays, can you tell us what time the blood alcohol test was administered in relation to when the incident allegedly happened? How many hours passed before we got this .05 blood alcohol reading?
I do not know the exact time. That's in the file. But we did try to extrapolate back from the time it was taken back to when this event would have occurred. And we were of the belief that it would have probably been at about a 1-0 by using the extrapolation. And that's people smarter than me that do that kind of stuff.
Is that considered intoxicated under Florida law?
Well, you're not supposed to drive at a .08, but.
Mr. Meggs, the victim's attorney indicated that they never expected this to go public. Once it did, obviously you did interview her. Was she willing to testify in this case?
I believe she would have been, yes. I believe she would have cooperated.
There seems to be a disagreement with the police and the victim's attorney on was she willing to go forward last February? What did you find in that case?
I didn't look into that aspect of it.
Two more.
Did you look into the possibility of other victims associated with either of the two men?
Oh, no.
And so when again, the delay of when the victim identified who she thought the men she had sex with, the time lapse between basically 10 months that lapsed or 11 months that lapsed between the time the police actually got the DNA sample. You have no criticism of the Tallahassee Police Department for allowing that time to go by that much.
You know, you ask kind of convoluted questions sometimes. So run that by me one more time.
Okay. The Tallahassee Police Department had the identity of the accuser, or of the accused, Winston and the other person. They knew that in mid-January. They didn't obtain a DNA sample until mid-November. And you have no criticism for why that didn't happen?
Well, for us to make our determination, that really is immaterial. It is his DNA. It was there on December the 7th when they did the rape kit. It was there when we did the examination. So criticizing does not accomplish a great deal. His DNA is in fact there. So it did not change.
Mr.
Was there any
Mason,
sign
is
that-
closed now?
Yes, it is.
Was there any sign that she expressed some hesitancy or reluctance throughout this process or moving forward with the charges? Was she a reluctant person?
You know, a sexual battery case, I don't find any, I don't believe I've ever met a sexual battery victim that was excited about going to court and testifying. There's always that reluctance. These are very serious cases. They're very hard cases to deal with. And I believe, you know, my deal with this is if we have a case, we're going to pursue it. If the victim will testify, and we expect them to testify and tell the truth, sometimes the truth is not easy to come out with and say, and these cases are always tough to do, and no one wants to go do it. And so to say there was reluctance, there's always reluctance. You know, we have that not only just in sexual battery cases. So many people just don't want to get involved at all. And so we have to do a lot of things to keep people involved. But we do expect, if we call a witness, for the witness to testify and tell the truth.
Say, was this a second DNA that was just discovered earlier this week, evidently, or confirmed earlier this week? Was that known to you through your interviews with the woman? Had she acknowledged having sex with two men that evening?
She acknowledged having sex with her boyfriend, yes. But she wouldn't tell me who her boyfriend was. And being a shrewd investigator, we found out. And we got his DNA. And then we confirmed.
And even after that was confirmed, what was the, can you give any time frame on that? That knowledge coming to you that there was?
It was before the sex. It was the DNA that was unknown was on the shorts of the that the person was wearing. The DNA of Winston was on her underwear.
Any idea why she was hesitant to tell you who her boyfriend was?
Well, tell us about your girlfriend.
Did you, and so in
I'm just getting at the idea of like, then presumably you brought that back to her attention, that now there's a confirmation that you would have sex with a second man. She remained insistent at the beginning of this week that she had been assaulted.
I haven't talked to her this week.
Okay. What has her story crumbled at all in your conversations with
her? Her recall of the events of that night have been moving around a good bit. There's some memory lapses. There were some major issues, and we were trying to determine about the memory lapse, what would cause that. Intoxication, some of y'all could tell me would cause you to have memory loss. Sometimes drugs can cause you to have that, and we found no evidence of any kind of major impairment or use of drugs. So,
but she never backed away from her claim that she had been assaulted.
Has not yet that I know of.
Were the inconsistencies in her story a major reason why you're not charging anyone?
They were problematic in our. It's not inconsistencies; it's lack of memory most of the time. There was some allegation that she had her head was hurt, but there was no outward signs of trauma, and so none of that was confirmed.
Was there any evidence of drug use by anybody in this case?
I don't think so.
When you interviewed her boyfriend, did he know James Winston?
He did not, and he did not really interview with us.
So you didn't interview him?
He would not speak with us. We spoke with him and got his DNA.
Mr. Miggs, what reason did the alleged victim give for not being able to identify the suspect?
She didn't know him. That's what she said originally.
So would you describe her as forthcoming or less than forthcoming?
I think she was somewhat torn and wasn't real sure about a lot of things. So I think she was forthcoming as much as she felt like she could, wanting to protect her family, herself, her own name. And that is not an uncommon thing for victims of crimes to do. They want to protect family, they want to protect their own name, they want to protect friends, they don't want to tell everything they know. And so
all right, one more, guys.
But, you know, in the timeline that was released by TPD, they indicated that the victim at some point did not want to move forward. Talk to me about that. Have you been able to validate whether that actually happened or not? And do you have to have that to move forward?
No, you know, one of the things and this is real important, you know, obviously we cannot move forward without a victim's corporation, except in certain kinds of cases. So her lack of cooperation and her lack of helping us, you know, would hinder the case. But you just need to remember that the cases are brought in the name of the state of Florida. And it's our job to determine if we have conduct that occurred in our community that merits punishment in the name of the state that we can prove. And if we can do that without regard to whether the victim, you know, obviously you don't have to have victim cooperation. John Hutchins just finished a murder trial. His victim in that case did not cooperate because he's dead. And so the case was brought in the name of the state of Florida. And that's what we would do. So now, if your victim comes in and says nothing happened, then that's a problem. And you'd certainly like to know that before you pick a jury.
Mr. Miggs, can you talk just in general, because I know we're cutting off, just what has this last 3 weeks been like for you?
I've got to know a lot of y'all in the last 3 weeks, at least on the phone, and it's been rather busy. And you know, I guess I could say it was there is a level of frustration with this, and I understand and I appreciate y'all doing the job that you do and the job that you have done. You know, I wish everybody had as much interest in all the other crimes that we have occur in our community as you did in this one. But
how many man hours would you say your office put into the investigation?
Well, we worked. We had 13 working days. Our office did, and Jason Newland was here late into the evening most of the time, and we've been so I don't know, 10 hours a day times 13 probably has that many hours. We've made several road trips, and we've contacted people in Ohio, and we've contacted people in the state. We've had a lot of cooperation from a lot of other folks. We enlisted the help of another state attorney in Florida to help us with this investigation. I enlisted the help of a prosecutor in Ohio to help us up there and find a witness. And we were a day behind him, but we were moving, and we did find him. So we've worked pretty hard on it.
You described the victim as she doesn't back away from her story. However, she's not cooperative? Is that what you're saying? She has not been cooperative?
Her testimony has basically has some problems with it. She can't remember some of the things, and that is a problem. And then some things she can remember, and so it does have these problems, which leads us to the point that we did not feel like we could move forward with a prosecution.
Okay, thanks. The public records, I know you guys are going to have to file public records requests individually to get the full report. We're guessing it should be ready in the next 24 hours?
I think it will be ready, I don't know. Well, what do you think, Miss Georgia?
Certainly in the next 24.
And what we plan to do, we have all of that. We put it on a disc, and the disc will be available to you so you can look at everything that we have, most everything that we can. And we have redacted. I would remind you that Florida has a rape shield statute, and you should not use the victim's name in this case and publish it. That's a crime, and we got plenty of work, and so don't make us come after you.
Thank you guys for being here.
Confirmed that Tim Jensen didn't know the DNA results?
who the DNA results belonged to before they were released?
I have no idea what Tim Jansen knew.
Yeah, if we're going to start asking what Tim Jansen knew, we're going to be here a while. Okay, thank you, guys.
Thank you.
Thank you all for coming.
Thank you, Mr. Mix.
FSU star quarterback Jameis Winston will not face any sexual assault charges. State Attorney Willie Meggs just wrapping up that announcement at the Leon County Courthouse. He says that he treats every case fairly and there just wasn't enough evidence to take this case to court.
Yeah, about a 25 to 30-minute long press conference there. Willie Meggs really kind of running through the gamut of their investigation. It's really been a quick but long and tedious 3 weeks. Again, the timeline, this case initially happening about a year ago, but he's saying, you know, his office didn't get the case until the end of last month, just a few weeks ago. He also addressed, you know, some of the criticism, some of the complaints against his office, against Tallahassee Police Department, but again, holding up the quality of the investigation here. Also talking a little bit about the victim in the case, saying some memory loss issues. Saying on that night, though, blood alcohol content level of 0.04, no evidence of any drugs, so they don't believe, you know, any outside factors or anything like that that had come into the case. So again, no charges against Jameis Winston. Now we're expected to hear a little bit more from Jameis Winston and his attorney Tim Jansen coming up in just a short time from now.
That's right. It's at 3:30. We will bring that to you live as well. And for all of the latest developments in this case, you can check out our website, WTXL.tv.